Good morning, ma'am. My name is Judge White. I'm presiding over this case. As the deputy said, just make yourself comfortable in that chair. Scoot up just a little bit. We need to get you about 12 to 15 inches from that microphone. It does adjust up, down, left, right as you need it. If you speak in a loud, clear voice right into it, it'll pick up everything.
Thank you.
Yes, ma'am.
Good morning. Please state your name.
Alicia Byers.
Can you spell your first name and last name, please?
ALICIABYERS.
And your relationship to Ashley Benefield.
She's my daughter.
And when did she start living with you in Florida?
I can't clearly remember.
Okay. Was there a time when Ashley moved in with you when she was pregnant?
Yes.
Okay. And she was married at the time, but it was just Ashley that moved in?
Yeah, he brought her down.
Okay.
And yes, and yeah.
And she moved in with you?
Yeah. He told me I needed to take care of her. He dropped her off.
Okay. So she stayed with you from that time on, correct?
Yes.
Okay. And does Ashley have a concealed weapons permit?
Yes.
Does she own firearms?
She doesn't now, no.
Did she own firearms
Yes.
then? Okay. How many?
2, I think. Yeah, 2.
Did she ever go to the firing range or
Yes.
anything? I'm sorry.
Yes.
Okay. How frequently would she go?
Well, we did all the courses to get the concealed carry, and I don't remember.
Okay. And very shortly before the shooting, she went to the shooting range with your neighbor, correct, John Fantz?
I don't think that was close to that time, no.
So it may not have been close in time, but they have gone together? Ashley and John Fantz?
I'm not sure.
Okay.
I don't know.
Okay. And you and your daughter obviously are very close. You lived together, just the two of you, right, for a while.
Mm-hmm.
And then once the baby was born, the baby lived there with you.
Correct.
Correct. Okay. And around that time of the shooting, were you planning to move to Maryland?
Yes.
And you had a house that you inherited in Maryland?
It was the house I grew up in.
Okay. And you inherited that house?
Yes.
So your plan was to move to Maryland with Ashley and Emerson, the baby?
Mm-hmm.
Okay. And Doug, Ashley's husband, was also moving to Maryland?
He was moving somewhere else. He was, yeah.
Okay,
He had found his dream job.
So he was moving to Maryland, but not moving into your same house?
Correct.
Okay. And he was moving, packing up to move at the same time you were?
I assume so, yeah.
But he was coming over to help
Yes.
you move?
Yes.
And on a regular basis, almost every day, he was at your house?
Maybe the last week.
Okay.
Yes.
Helping move boxes and things like that?
Yes.
And you all rented a U-Haul, right?
Somebody rented a U-Haul. I don't know who.
It was in your driveway, though, correct?
No, it was not my driveway.
The day the shooting happened, was it in your driveway?
I think it.
If you don't know,
The
that's
U-Haul was getting there when I was leaving.
okay.
Yeah.
But you also had a pod, one of
Correct.
those
That was in my driveway.
in your driveway.
Yes.
Okay. On the date of the shooting, what time did Doug get to your house? Do you remember?
No, I mean, it was, I can guess, maybe like 5 or something. I don't know.
So it was still light out?
Oh, yeah.
And maybe in the afternoon sometime?
Yeah, I don't clearly know.
Okay. So when he showed up, what did you do? Did you stay there or leave?
I was leaving when he pulled up.
And where did you go?
We went to the park.
Okay. When you say we, who is we?
Oh, Emerson and I.
Okay.
Yes.
So just you and Emerson, and how old was she at the time?
So I guess 2, maybe? Yeah.
Approximately.
Yeah.
And at the house, was it just Doug and Ashley then?
Yes.
When you left?
Mm-hmm.
And you've obviously been in contact with your daughter almost every day since the shooting, correct?
Leading. No, rule.
You've been in contact with her basically every day, correct?
Not initially, no.
For the last several years, you've been in contact with her every day.
Well, yeah.
Okay. And
No, okay, yeah.
did she ever, during any of these conversations, tell you what happened when she had to shoot Doug?
Never. Nope.
When you came back from the park, I'm assuming she was already in the squad car or she was already with law enforcement?
I had no idea where she was.
I'll sustain.
Okay. So at the time that the shooting happened, she didn't tell you what happened?
No,
Correct.
we've never talked about it.
And
No rule.
to this day, you've never talked about it?
No.
Thank you. No further questions.
Of course.
Good morning, Ms. Byers.
Morning.
Are you nervous?
Yes, very.
Scared?
Yeah.
All right, let's try to relax. If my questions aren't clear, please just ask me to repeat it.
Okay. Thank you.
Was there ever a time when you and Ashley resided here in Bradenton, in the home, that Doug lived in that house?
Never.
Would it be safe to assume, and perhaps you can enlighten us a little bit, how was your relationship with your granddaughter, Emerson?
Oh, very good. Yes,
Okay.
we're very close.
And would you try to spend time with her?
Yes.
Would that include you taking her somewhere on a regular type basis?
Yeah. Oh,
Would that be to the park?
yes.
And tell the ladies and gentlemen of the jury, Ms. Byers, how often you engaged in that practice of you and Emerson going to the park?
Usually several times a week. And we'd go after it cooled down because the park is not a very good, tree coverage, so it was very hot. That was the only comfortable time to go.
So we think trying to avoid the heat or minimize it'd be later in the afternoon?
Yeah, it was brutal out there otherwise.
Yeah.
Florida,
Almost as bad as it is now.
Right, exactly.
How far away was the park?
It's a short walk. I mean, we'd always walk over there, so I don't know, take us maybe 5 minutes to get there.
Okay.
So-
And on this particular day, I think you told Miss O'Donnell, if I'm not mistaken, you were actually in the process of going with Emerson to the park when Doug arrived?
Yes, we're walking down the driveway and I had her in the stroller.
And on this particular occasion, there was nothing unusual about you going to the park, just
Oh,
like
no.
you
No,
did
that's when-
regularly?
Yes.
Give me a moment, Your Honor, please. I believe that's all I have, Your Honor. Thank you, Mr.
Can you redirect?
No.
Oh, hold on, Dan, don't get up yet. No redirect.
No.
Can this witness be released?
Yes.
Yes.
Ma'am, you were released from your subpoena. The rule of sequestration had been invoked, but you're now released from your obligations.
Okay, all right, thank
There you
you.
go. Thank you.
Judge, I apologize. In consulting with counsel, I do think I want to leave my under subpoena for
All right.
Sorry.
Ms. Byers.
So what does that mean?
Yeah, I can explain that.
Okay.
All right, so what that means is you remain under subpoena and subject to being recalled at the trial.
Okay.
The attorneys at the beginning of the case invoke what we call the rule of sequestration. So the instructions I'm going to give you are similar to what you've already probably been told by the attorneys. You're not to discuss your testimony here in court, the questions asked of you with anyone else, including the attorneys. You can't talk with other witnesses about what their testimony was or the questions they were asked. And it's my understanding this may be online. You are prohibited from watching anything that's going on within these four walls, ma'am, until you're released from your subpoena or until the jury comes back and the verdict is released. Okay? All right, thank you, ma'am. You're free to go for now. All right, State.
State will call Barbara Russell.
Oh, this way. There you go.
You solemnly swear or affirm the testimony you're about to give you the truth, the whole truth, and nothing but the truth, so help you God. I do.
Thank you so much.
Good morning, ma'am.
Good morning.
My name is Judge White. I'm going to be presiding over this case. As the deputy said, just make yourself comfortable in that chair. Get about 12 to 15 inches away from the microphone. It does adjust up, down, left, right, however you need it. But if you just speak directly and allow for your voice into the microphone, it'll be better.
Thank you, sir.
And please state your name.
Barbara J. Russell.
Can you spell Barbara and Russell?
BARBARARUSSELL.
And what is your profession?
I'm a licensed clinical social worker. I have a doctorate in clinical psychology, and I work as a clinical and forensic mental health professional.
Okay. And how long have you known Ashley Benefield?
I've known her since April of 2020.
Okay. And when you first became involved with Ashley, it was on a professional level, correct?
Correct.
All right. And then since the time that you had that interaction, you have stayed in touch with Ashley.
Correct.
And subsequent to the shooting that happened, she actually moved into your house, correct?
Correct.
Okay. And who all lived at the house?
Myself, my husband, and my 19-year-old daughter.
All right. And approximately how long did she live at your house?
Approximately 8 months.
And you would see her on a daily basis?
Pretty much, yes.
Okay. Did she, when you first spoke, when did you first see her or speak to her after the shooting?
About 1 o'clock the following morning.
Okay, so this happened in the evening time, so it would have been 1 o'clock the next morning. And at that time, did she say to you, "Oh my God, he came after me, I had to shoot him"? Did she say that?
She didn't discuss what had happened at all, nor did I ask.
Okay. And to this day, are you still in contact with her?
Not that one. I'll overrule on that question.
To this day, are you still in contact with her?
Yes.
Okay. And to this day, has she ever told you what prompted her shooting, Doug Benefield?
She never gave any kind of narrative of what prompted the shooting. My understanding is that
I just want to know if she told you. I just want to know what she told you. She did not tell you anything, correct?
She never gave me any narrative about what had happened.
Thank you. No further questions.
Cross, sir.
Good morning, Dr. Russell. I have a question from your own personal knowledge. You're aware that Ashley's lawyers instructed her not to discuss the facts, correct?
Of course, any good lawyer would do that.
Give me just a moment, Your Honor.
Of course, yes, sir.
Did there come a time, Dr. Russell, when a detective, Warren, contacted you about the case?
Yes.
Did you have discussions with Detective Warren?
I met with him once, yes, for about 90 minutes.
And in that meeting, did you relate to him that...
Objection. Yourself.
I'm asking a question to this witness.
I understand, but if it calls for hearsay, why don't you approach so I can hear what the question's going to be?
When you spoke to Detective Warren Justin, you identified yourself.
Correct.
This was a face-to-face conversation.
Yes.
If you were to tell us today in court about the discussion you had with Detective Justin, would it be any different than what you told Detective Justin on that day?
No, of course not.
You have an opinion, do you not?
Objection.
Rephrase. As you sit here today, do you have a conclusion?
Objection.
Sustained.
All right, give me a moment. Can I see the pictures that were entered yesterday? Dr. Russell, you had an opportunity that morning, from what you had to say at approximately 1 o'clock, technically the next day, to observe Miss Benefield, correct?
Yes.
I'm going to pass you a picture that's previously been marked as State's Exhibit number 21, picture of Ashley Benefield that was taken on the day of the incident.
Yes.
May I approach you?
Yes.
Does that picture reflect any swelling to Ashley Benefield?
Objection. As interpreting the picture.
Sustained.
Did Ashley Benefield look like that when you saw her prior to the day of the homicide?
Prior to the day, no.
Okay, what was different about her?
When I saw her after the incident, there was edema, sweat swelling on the side of her face.
Okay, and did that include her right eye?
It included her left eye.
Left eye, rather?
Yes.
Okay, and when you saw her before the homicide, did she have swelling on the left side of her face, on her cheek and her eyelid?
She never had, no.
In fact, when you saw her immediately following the incident that morning at about 1 a.m., was there any indication that by Ashley that her head was hurting?
Objection. Here's second.
Sustained.
Spontaneous statement, Your Honor.
That existing mental, emotional, physical condition.
Can we vote?
Yes.
Did Ms. Benefield that morning give you any indication that she was in pain?
Yes.
And did you refer to any particular area?
Yes.
What?
Her head.
Thank you.
Would you rather?
No.
Can this witness be released?
Yes. I'm sorry. No. She's to remain under subpoena. She can be released.
Ma'am, rule of sequestration has been invoked by the attorneys, so that means that until you're released from your subpoena or until the jury is discharged, you're not to discuss your testimony in this case with anyone outside this courtroom, including the attorneys. You're not to talk with any other witnesses about your testimony. You're not to talk with any other witnesses about their testimony or the questions that were asked of them. And it's my understanding this may be online, so you're prohibited from watching anything that's going on within these courtrooms.
Absolutely.
Thank you, ma'am. Just leave the picture there.
I will do so. Thank you.
All right, State.
Judge, the state called Lieutenant Dan Dickerman. I knew he was caught in the line, so I just wanted to make sure it's there.
We have an issue here I'd like to take up for just a moment. I don't know if you
He's
want to see it for 5 minutes.
Hold on 1 second. Approach it. Oh, sir.
Sir.
I'm Judge Ryder presiding over the case. As the deputy said, just make yourself comfortable in that chair. You're about 12 to 15 inches from the microphone. It does adjust up, down, left, right, how you read it. Just speak in loud, clear voice and shoot your ready.
Yes, sir.
Good morning.
Good morning.
Please state your name and spell your last name.
Daniel Dickerman, Dickerman,
Where do you work?
at the Manatee County Sheriff's Office
How long have you worked there?
for almost 29 years.
What is your current position?
I'm a lieutenant in road patrol.
And what was your position back in 2020?
I was the senior homicide investigator assigned to the Manatee Homicide Investigative Unit.
Okay, so Manatee County, say that again?
Manatee Homicide Investigative Unit, MHIU.
MHIU. Okay,
Yes.
so you were the senior investigator in that unit?
Yes.
Okay. And if you could just explain a little bit, what is that unit?
So that unit is a group of detectives formulated from all the agencies within the county, the Sheriff's Office, Braden Police Department, Palmetto Police Department, and all 3 beach agencies. We all respond out to all homicides that occur within the county, regardless of city jurisdiction, everything, so we can all work together and investigate that and determine if any criminality as a result of that homicide will need to come forward.
And just discuss a little bit how you work as a unit, and is that different than how a detective may work in a different part of the Sheriff's Office?
Yes, in the Sheriff's Office, most cases are assigned to a single detective. They go out, they do all the work, they write the report, they bring everything together in a normal, smaller case. In these cases, we determine what we call a lead detective. That lead detective then becomes, for all intents and purposes, the supervisor of the case. He makes assignments. We go out, all the other detectives, we do our respective assignments, we report back. The lead detective becomes a basic gathering point and a keeper of all the information to make sure the flow goes smoothly to one location and we're not duplicating efforts or stepping over each other's toes, and then he makes the ultimate decision once he has all the information.
Okay. And are you, as a unit, a part of any decision-making that happens within the unit, or that happens in a case?
Yeah, we have meetings on every case
Okay.
to discuss the comings and goings and happenings of the different case.
And so did you work in this unit, the MHIU, at the time that the shooting occurred?
I did.
On the date of the shooting, were you notified of the shooting?
I was.
Okay. And about what time was that,
It
approximately?
was between 7:30 and 8 p.m.
Did you go to the scene?
I did.
And when I say the scene, where the shooting happened.
Yes, to the neighborhood of White Rock, I believe it was.
Was the defendant there?
Yes.
Where was she?
She was in the back seat of Deputy Burley's patrol vehicle.
Did you go into the house?
Not at that point. I did after the crime scene unit had already documented everything and made sure nothing could be contaminated, done their investigation inside. Then I went in briefly at the end.
Okay. And what did you see?
I saw some blood trail on the floor, a bullet strike in the wall of the bedroom from a projectile, and that's about it.
And were other members of your unit there at that scene?
Yes.
Were there other members of the unit at other scenes or other places?
Yes, detectives were also sent to our main offices, Criminal Investigation Division, which is where our interview rooms and our offices are located.
Okay. And from the beginning of when you arrived on scene, you knew that there was a self-defense element of this crime. Did you know there was a self-defense element when you got there?
Object the leading. I'll overrule on that.
Yes.
Okay. While you were at the scene, were you made aware that the defendant was going to be going to the station?
Yes.
Okay. Was the defendant's mother, Alicia Byers, there?
Yes.
Did you speak to her?
Yes.
And at some point, did she hand you a phone?
She did.
Okay. And did you know why she was handing you the phone?
Originally, no, but then I found out shortly after.
Who was on the phone?
A lawyer.
Okay. And did you speak to that lawyer?
Object. Sustained.
Did you explain to Alicia Byers what was going on and where her daughter was going to go?
I did.
And ultimately, how many lawyers ended up at
Relevance.
If you want to approach and explain the relevance.
at the time the defendant went to the station, was she under arrest?
No.
Was she ever arrested that night?
Object leading.
Sustained.
When was she arrested?
Sometime in November.
Okay. And the shooting happened?
In September.
And that seems to be a month or two delay. Do you know what delayed that?
But for the investigation to continue into the self-defense claim.
Okay. Did you go to the neighbor's house, John Sant?
I did go there briefly, yes.
Okay. And did you have any discussions with him or
I
anyone?
did not, no.
Okay. Was Child Protection Services on the scene?
Yes, they were called to the scene.
And just briefly, what is Child Protection Services?
Objection. Relevance. Consistent with the court's prior concern 403.
Overruled.
What is Child Protection Services?
At the time, it was a division of the sheriff's office entrusted with protecting the children from abuse, or make sure they're in good locations, or just make sure they're healthy.
Okay. So do you know why they were there?
Objection.
Yes.
Sustained.
Did CPS try to speak to Alicia Byers?
Yes.
Okay. Were you present when
Yes.
Alicia Byers?
Yes.
Was Alicia Byers cooperative with them?
I wouldn't say fully cooperative. She did ultimately answer a vast majority of the questions, but not cooperative per se.
Okay. And was there anyone else present at the time when they were trying to speak to Alicia Byers?
Off and on, Barbara Russell was present.
Okay. Did you also assist in executing a search warrant?
Yes, I was on scene.
And where was that search warrant? Was that at the house?
At the house.
Okay. Did you have any assignments for gathering evidence?
Yes.
And what evidence was that?
To originally look for video in the area of the park of the neighborhood.
And did you do that?
I did.
Were you able to obtain video?
I was.
And on that video, did you see what we believe to be Alicia Byers and the child at the park?
Yes, they were at the park.
Did you also obtain other types of videos?
Yeah, I also viewed ring video from the scene itself.
Objection, relevance.
What video?
Ring from the scene.
Overruled, I mean, you can say you viewed it.
And in viewing that, did you see any part of the incident that we're here about? Was it captured on the ring camera?
The shooting, no. The arrival of the U-Haul and the arrival of the deputies were on there.
Okay. I have no further questions. Thank you.
Thanks.
Good morning, Lieutenant.
Good morning.
So through your testimony, among other things, the state proved this morning that there was a U-Haul truck there
Yes.
and that the deputies arrived
Yes.
and that there was a homicide.
Yes.
Okay. Now, you mentioned that often the practice is when you respond to a homicide, it takes some time to conduct an investigation to determine if there's criminality.
Absolutely.
Okay, so in other words, you don't come upon a homicide and determine as soon as you see a dead body it's murder.
Correct.
Okay. If I wanted a job in your unit that you supervise and I felt all homicides are murders.
Objection.
Fair question, Your Honor.
Objection. Pre-trial ruling.
Same.
You mentioned that the arrest of Miss Benefield, well, let me start from, I think you told us she was in the back of the squad car.
Yes, sir.
She was in handcuffs.
Yes.
And this is a squad car with the doors that you can't open from the inside in the back, correct?
That's correct.
With a cage.
Yes.
So she's in the back of the squad car, in handcuffs behind her back,
Yes.
in a car with a cage, and you can't open the doors, but she wasn't under arrest.
No, she wasn't charged with anything.
Okay. So, I think you told us that the reason for her being arrested approximately 6 weeks later, I think, was so that the investigation could be conducted.
Correct.
Because you had to determine if there was criminality.
Correct.
Okay. Could have been a homicide that was self-defense.
Could have been. That was the claim.
That's the whole point of the investigation.
Absolutely.
And that kind of an investigation, understandably, takes time
It does.
and patience
Yes.
and professionalism
Yes.
and knowledge and experience.
Yes.
Do you know how old Lieutenant Alicia Byers is?
I don't.
Do you recall meeting her?
I do.
Approximately, give us your best shot.
I mean, I would guess in her 40s to 50s.
All right. Was she a young woman?
No.
She was pretty exhausted that day, wasn't she?
She appeared to be. There's a lot going on.
Would it be a fair statement, Lieutenant? You seem like a pretty straight guy. Was she emotionally distraught?
Yes, there's a lot of emotions going on there. Yes.
In fact, her first thought upon coming back from the park with the daughter and seeing the cars was that her daughter was dead.
Smoking.
Unless you'd like to make an argument for an exception, then you can.
Rest chest time?
If you'd like to approach.
It's all right, Your Honor. I think, Lieutenant, excuse me, you told us that you went into the residence after crime scene had completed their portion of the investigation.
Yes, sir.
And do you recall crime scene was there before or after EMS?
The crime scene comes after EMS. Sanctity of life always comes first.
All right. So EMS was there first, and you were there, so you know they dragged Mr. Benefield out of the home from
Yes.
the bedroom.
Yes.
So when you told us that crime scene was there to preserve the scene, can we agree, Lieutenant, that what crime scene preserved was the scene following the EMS people not only working on him in that bedroom, but moving?
Yes, as always, that we preserve the scene after we attempt to save a life.
Okay. And so those crime scene photos show us, for example, what that scene looked like when crime scene took the photograph.
That is correct.
It doesn't show us what the scene looked like when EMS was running around doing what they do.
That's not possible. No, that's correct.
Okay, and that would have included the initial deputies on the scene as well.
That's correct.
Give me just a moment, Your Honor.
Yes, sir.
Thank you, Lieutenant. Appreciate your candor.
Thank you, sir.
Redirect.
No.
Can this witness be released?
Yes.
Mr. Taylor, can this witness be released from your subpoena? Sir, you were released from your subpoena. You're free to go.
Yes, sir. Thank you very much.
Stay.
Can we approach?
Hello, ma'am. My name is Judge White. I'm going to be presiding over the case. Get yourself about 12 to 15 inches from the microphone. It does adjust up, down, left, right. Just make yourself comfortable. If you speak directly into the microphone with a loud, clear voice, we'll hear everything. Thank you.
Good morning.
Good morning.
Please state your name.
Stephanie Murphy.
How do you spell first and last name?
Stephanie is Stephanie. Murphy is Murphy.
And what is your profession?
I'm an attorney.
How long have you been an attorney?
This is my 23rd year as an attorney actually in the Sarasota-Bradenton area.
And are you with a firm, sole practitioner? What do you do?
My husband and I have our own firm, and I've had that firm for 16 and a half, 17 years. Before that, I was at a larger firm in Sarasota.
And what is your topic of law that you practice?
I practice family law, which is generally comprised of divorce, custody cases, or what used to be called custody cases, and adoption cases.
Okay. I want to ask you about Doug Benefield. Did he hire you?
He did.
And approximately when did he hire you?
He hired me in March 2018. He came for a first consultation on the 13th. He hired me on the 14th of March 2018.
And what was the purpose of your duties to begin with?
Initially, the purpose of hiring me was to draft a letter to Ashley Benefield, who was pregnant with their child at the time, which I did. I drafted a letter and sent it the day after I was retained. But the purpose of that letter was actually just to initiate.
Relevance. She stated that she sent a letter, that she was retained to send a letter. Now going to explain something.
Okay, overruled.
What was the purpose of the letter?
The purpose of the letter was to open the door for discussion about Doug's participation in the upcoming birth of their child, but also to advise that if she did not feel comfortable with him being present at the birth, he was respecting her need for space.
And when did you send that letter?
I sent that letter on March 15th at 9:59 in the morning by email to Ms. Benefield.
Okay. And did you receive a response to that letter?
I did not receive a response directly from Ms. Benefield. She checked herself into Tampa General the next day to start induction.
Sustained.
So when was the child born?
Well, the child was born early. She was born on March 19th, I believe, is when she was finally born.
And you said early. How many weeks early was that?
Well, the child was originally scheduled, or her due date was April 8th. So I think
Sustained.
Okay. So you said you never received a response
not from Ms. Benefield.
from Ms. Benefield about the letter.
Correct.
And to your knowledge, did Doug ever receive a response?
To my knowledge, he did not receive any response from Ms. Benefield or anyone on her behalf.
Okay. And I think you might have said this, but the child was born on what day?
She was born on the 19th of March.
Okay. And at the time the child was born, did you or Doug know that the child was born?
No, gosh, we didn't know for a good 5 or 6 weeks after she was born.
Okay. And how did you find out that the child was born?
I actually found out because I had been monitoring the docket for Manatee County court system, just because there had been no response. And so on May 6th, I saw that Ms. Benefield had filed a petition for protection against domestic violence on, I think it was April 23rd. So about 2 weeks prior to me finding out, she had filed the petition. And in that filing, there was, she identified the birth date of the child, as well as I think the child's name, which is the first time we learned about that too.
Okay. And you said she filed a petition for, what did you call it?
It's a petition for protection against domestic violence. So it's an injunction. A lot of people refer to it as a restraining order, but it wasn't granted as an injunction at the time.
Okay. So when, just for knowledge of people that may not know, when someone does a request for an injunction, what is sort of the procedure that it needs to go through?
So the person who files a petition for an injunction, they file it at the courthouse in the clerk's office, and then that gets sent up to the judge, usually a family law judge who's just in charge of injunctions that day. And then the judge has 3 options, I believe. One is just to deny it completely. The second option is to grant a temporary injunction, but then there's a follow-up or a return hearing.
I'll overrule.
And then the third option is what happened in this particular case, is that the judge denied the petition as a temporary injunction, so there wasn't enough evidence in the petition to warrant a temporary injunction, but a hearing was set to review it.
Okay. And when was that hearing set approximately, to your knowledge?
I believe it was originally set for May 8th, but Ms. Benefield made a request to continue that hearing.
Okay, so it was then continued?
It was.
Before the hearing actually happened, did you file any documents on Doug's behalf?
I did. So, well, of course, I filed a notice of appearance in that injunction case. And then we started an entirely separate case. So I filed on Doug's behalf a petition for a parenting plan unconnected with divorce. And so he wanted to establish a parenting plan so that he had really time sharing and decision making for his daughter, because he had none of that up to that point because she was withholding all that information.
And some of the lingo may be familiar to us, but so time sharing, what is that?
I'm sorry. So time sharing is what lay people and a lot of people used to generally call visitation. So it used to have custody, parent had custody, and then another parent had visitation. That was changed, and now in Florida at least, and especially in our circuit, we have parenting plans, which is a comprehensive agreement or an order by the court that lays out all the details of parenting as a not intact family. So the major components are decision-making and time-sharing schedule, so how often the child spends with each parent.
And you said not connected with a divorce proceeding?
Right.
So I would assume that means it can either be with a divorce proceeding or without?
It can be, and of course it can be also in a paternity case, so parents don't have to be married. But in this case, because they were married, Doug was not initially pursuing a divorce because he hadn't had any contact with Ms. Benefield for a while. His initial...
Sustained.
Okay. So initially it was not connected with divorce.
Right. His priority was his daughter.
And you mentioned the injunction case and then your motions, were they two different case numbers?
They were two different case numbers. So the injunction case number was 2018 DR 1823, and then the new case that I filed for Doug was 2018 DR 2318. Now they're companion cases though, so they might be separate cases, but they travel together as companion cases and they're assigned to the same judge through this unified family court program.
So when the hearing was set and ultimately heard, were both of those case numbers heard?
Both of the case numbers were heard, but it wasn't our first pleading wasn't the same pleading that was heard at the time of the injunction.
Objection. It's narrative, non-responsive to the question.
Sustained.
So what generally were the allegations in the injunction petition?
Generally, Ms. Benefield was alleging that Doug had been violent toward her. She alleged that he hit the dog, fired a gun into the ceiling. The biggest allegation was that he was poisoning her and their child in utero with heavy metals.
Okay. When was this hearing finally held?
The hearing was held in two parts, actually. It was July 30th, and then the second part was September 17th.
Not responsive to the question, Your Honor.
Overruled.
And that was the year 2018, correct?
Yes, it was.
Okay. And what judge was this in front of?
It was in front of Diana Moreland.
Okay. And you said it was held on 2 days. Why was it held on 2 different days?
It took a very long time. So both sides had experts, toxicologists, and we had a number of other witnesses appearing. We had,
Objection. Not responsive to the question.
Overruled.
there were also people from the child protective team testifying. And so there were too many hours, and so we couldn't squeeze it all into one day.
Okay. And ultimately, at the end of this, did Judge Moreland make a decision?
At the end of that, she did. There were other decisions along the way, but ultimately she made a decision on the two matters that were set as the companion cases.
And what I meant was on the second hearing day, did she make a decision?
Yes, she did. September 17th.
And what was that decision?
There were two parts because, there was two cases.
Objection, Your Honor, just final decision.
For the prior motion?
Yes.
Yeah. Overruled.
Go ahead.
Thank you. For the injunction, she made a lot of rulings and a lot of findings about lack of evidence and then denied
We don't want to talk about what went into that. We just want to know what her ruling was.
Okay, she denied the injunction. So that was the first part.
Okay. And then the second part?
The second part was on the parenting plan case, the time-sharing case. And so in that, she entered a ruling for a time-sharing schedule. That would be an introduction schedule because Doug at that point had never met his daughter, and that would increase over time on a temporary basis. And then she entered a ruling that he would have ultimate decision-making authority over the child's medical needs and otherwise share decision-making.
Overruled.
And otherwise, I'm sorry.
Otherwise share parental responsibility, which is joint decision-making.
Okay. And as of that day, was Judge Moreland's ruling timed? Like, was it immediate? Was it in the future for the time sharing?
It was immediate. Well, not that day, but she said the first day, and it was just a couple of days later, the 21st, which is when Doug was supposed to meet his daughter for the first time.
Okay. And this time that Doug met his daughter for the first time, were you present?
I was, yes.
And where did this happen?
It happened at Manatee County Sheriff's Department on, I think it's 301.
Did you arrive together or separate? What's up?
Oh, we arrived separately. When I got there, Doug was already there.
And how old approximately was the baby at the time?
I think she was around 6 months old. She was born in March, and this was then the 21st of September. It's about 6 months.
And can you explain how that interaction went? Did you observe it, first of all?
I did.
Okay.
So when I arrived, I got into Doug's truck, and we just waited because we were there early. And then he saw Ashley arrive with the baby. And so he pulled the truck closer, and then we both got out of the car and started walking toward Ashley. And then it was just an odd kind of interaction, actually. She turned to me with this nasty look on her face and said to Doug,
I'll sustain as to the characterization.
she turned to Doug and said, "Are you dating her?" And so obviously we both said, well, of course not, no. And then I hung back, and Doug then was standing there, and Ashley approached him with Emerson, and they started talking. Eventually she let him hold the baby, and they just kept talking for a few minutes. Then I was advised that they were going to be leaving together, strangely, that Ashley was going to be going with them for the time sharing.
Was this a surprise to you?
Absolutely. We had just been in knockdown, drag-out litigation for months with just horrendous allegations that were unfounded, and yet she said, "I want to go with you," and he said, "Okay."
Objection to the characterization of the allegations being unfounded and continued editorializing by the witness.
Can we approve?
Sustained.
So when they told you they were going together, what was your response?
I pulled Doug aside and I cautioned him about going with her. I advised, I'm his attorney, and so I did advise him. I said, "This isn't a good idea. She's trying to set you up for something. don't do this. And he said, I understand, I'm going to go ahead and do it anyway. And so I stayed and observed as Ashley strapped the car seat into the back of the truck, and she got in the truck with Doug, and then they left together for his first time sharing with his baby, for their baby.
So after this first time sharing, did this seem to start a time of peace, so to speak?
It was a time of peace. Actually, before the 26th, but on the 26th, Doug and Ashley both signed a stipulation that I had drafted at Doug's request, which expanded the time sharing that Judge Moreland had ordered at the hearing on the 17th. So within a week, they had already agreed that he was going to have even more time sharing than Judge Moreland had said.
Okay.
And so that was filed in a court file. It took away the restriction of meeting at the sheriff's office if they chose.
Non-responsive.
Overruled.
So yes, that was the beginning of a time of peace that extended for quite a period of time.
And during this time, well, how long did that last, the peace?
It lasted, to my knowledge, about 11 months.
Okay. And during this 11 months, did you see Doug and Ashley?
I saw them in magazines. Actually, they were attending gala events together, and so they were kind of
Speculative and hearsay.
so other than seeing them together at the sheriff's office, I didn't personally observe them out in public, but I did. Like I said, I saw them in various forms of media. They're quite the couple.
Okay. And you said this peace lasted about 11 months. What broke this peace, to your knowledge?
Well, it was my understanding from Doug that they were getting ready to move in.
Hearsay.
Let's not talk about what happened with what Doug said was supposed to happen. But during this time, did Ashley stop speaking to him?
I'm sorry, I didn't hear the question.
During this time, did Ashley stop speaking to Doug?
Objection. How would you know it calls for hearsay?
Effect on the listener.
Overruled.
Thank you. They continuously spoke to one another for 11 months until August 16th of 2019.
Objection. I thought that was the yes or no, Mr. Objection, non-responsive.
Sustained.
Okay. So around this time, you said November 16th?
August 16th of 2019.
Okay. What happened at this time?
Doug was supposed to be moving in with Ashley and her mother, Alicia. He had moved all these things in.
And we're not going to talk about the specifics of that.
So, counsel, I'm sorry to interrupt. I request the instruction from the court about,
Can we not do speaking objections?
Do you need to approach? Ms. Murphy, at this point, I'm going to excuse you from the courtroom so we can have our hearing. Ma'am, the rule of sequestration has been invoked. You're not to discuss your testimony or the questions that have been asked with anyone, including the attorneys, any other witnesses, any third parties. You're not to talk with other witnesses about questions they were asked or testimony they provided. And it's my understanding this may be on the internet somehow, so you're not supposed to watch anything at all that's happening within these four walls.
Okay, thank you.
All right, the witness is out of the courtroom. Do you have,
Judge, I don't have a specific instruction. We may need to craft one, but what I'm looking for so that the court knows is an instruction to the jurors that these hearsay statements that have been repeated by the witness thus far, and for purposes of the remainder of her testimony, the other statements she will undoubtedly try to get out are not being offered for the truth of the matter, but rather being offered for whatever reason that the court wants to ascribe to provide the context of the narrative in response to the question.
so as I said, go ahead, do you want to be heard?
No.
So as I said, I'm not aware of a standard jury instruction in the 2.1 to whatever it is, 2.8 range or 2.9 range that does that very thing. So I want to give the parties the opportunity with the jury not present to look and see if there's a standard jury instruction.
I don't think
I can give it. Like I said, I drafted one for a prior homicide trial where there were a number of statements that were admitted by me, by the decedent, where there were objections, just like we're having now, numerous objections to hearsay. But obviously none of them were being offered by the state for the truth of the matter asserted. That's what was argued, and I made that finding. So in order to have just a blanket instruction, I crafted the following, and the parties ratified it. So I gave it specific to the decedent's statements in that case to, it was either an attorney or some sort of financial planner about some final wishes. And here's what it says. You are about to hear statements made by declarant, and I put the name in. These statements are relevant only to explain the reaction and responses that they elicit. That is, the effect those statements had on a reader or a listener, because there was also a letter that was involved. You are not to consider the statements by declarant's name as true, but only to establish the context of readers' or listeners' actions, reactions, and responses.
that would be fine.
Except for that you are about to hear, because they've already heard some, so.
what the court want to substitute, you've already heard and may continue to hear. And by suggesting that, I'm not suggesting that I agree to the further admission of hearsay or her interpretation. That's not directly responsive to the question.
So reserving on other objections. And certainly, there may be objections you have as we go where you think that they are not being offered for the effect on the listener. And that it's hearsay without exception. So those still may come up. All right, so when we bring the jury back in, you want me to give that instruction?
Please.
You have heard and may continue to hear statements made by Doug Benefield to Stephanie Murphy. These statements are relevant only to explain the reactions and responses that they elicit. That is the effect those statements had on Ms. Murphy.
If I may, Ron?
Yes.
I would suggest that it just name Stephanie Murphy, not Doug Benefield, because I think in her testimony it's been broader than that. So I think by identifying the instruction as it relates to this witness, the jurors will consider the testimony appropriate.
All right, so let me go through this again because I have declarant and recipient, reader or listener. So you have to tell me where you're talking about.
Sure.
You are about to hear statements made by Doug Benefield.
Yeah.
These statements are relevant only to explain the reactions and responses that they elicited, that is, the effect those statements had on Ms. Murphy. You are not to consider the statements made by Doug Benefield as true, but only to establish the context of Stephanie Murphy's actions, reactions, and responses.
Okay, so here's my concern. For example, Ms. Murphy also testified about Judge Moreland, about a couple of the medical records and things like that. And I would prefer, and I think the fairest interpretation would be, ladies and gentlemen, Stephanie Murphy has previously said and may continue to refer to out-of-court statements. You are instructed that these statements, if and when made, you should not consider them for the truth of the matter asserted, but rather for context as it relates to Stephanie Murphy's testimony. That's how I think appropriately it should read, Ron.
Response?
Judge, I think these things that he's talking about were objected to and they were stopped. So I don't know that it's better to highlight it anyway, but I don't know if adding names in of people to fit this, statements of Doug Benefield, this person, that person, this person, I don't know that would be effective to the jury. So I'm a little confused about how to handle it.
All right. Any final thoughts?
No.
All right. I'm open to giving limiting instructions, curative instructions that are suggested by the parties. However, the most recent one proposed by the defense, I don't think is legally accurate. It would be telling the jury to disregard testimony and evidence that's already been presented. I thought the request from the defense, because the objection came specific to Doug Benefield was supposed to move in with the defendant, and that's where we stopped. So it was my understanding that the instruction that was requested was specific to any statements made by Doug Benefield to Stephanie Murphy, that those are only relevant to explain the subsequent actions and effect that those statements had on Ms. Murphy, and telling the jury not to consider the statements by Doug Benefield as true, but only to establish the context of Ms. Murphy's subsequent actions, reactions, and responses. I don't think the limiting instruction proposed by the defense is the correct one to give. So I'm open to considering language that we can talk about some more, but no, the one you just said I don't think is appropriate.
All right, well, the message that we're trying to give to jurors is that when this witness makes hearsay statements, that the jurors should not necessarily receive that information as true, that it is being offered rather not for the truth, but to show the effect that it had on this witness. After all, that's what this witness is testifying to. She did not limit it just to what Doug told her, Judge. She's referred several times to what she heard from Ashley. She's referred to medical records and to allegations. She's also referred to Judge Moreland's decisions. She's expanded upon them. She's incorporated hearsay into her testimony. This was why I approached the bench before she took the stand, because I anticipated this. That's the way she's conducted herself in the deposition and in all of her prior statements. So what I want, respectfully, Your Honor, on behalf of Ms. Benefield, what I want the jurors to understand is that as it relates to Ms. Murphy's characterizations based on hearsay, that they should not receive it for the truth of the matter asserted. Rather, they should receive it to show the impact that it had on Ms. Murphy.
Response.
Judge, first of all, anything that Ms. Benefield said is not hearsay, so it does not qualify under any of this analysis. I do not believe she said anything about medical records. I may be wrong. She did start to mention that she checked herself in the hospital, there was an objection, and she stopped speaking. So I would agree that that your idea is correct and that should be the instruction.
Final thoughts.
So, everything that a defendant says is not necessarily admissible. It's not necessarily relevant. It's not necessarily an admission. For example, Judge, if during the course of all of this, Ms. Benefield may have stated how much she loved this routine of a mouse named Topo Gigio, I think we could agree that that would have no relevance. And if this witness wanted to get up and talk about that merely because that is something that Ashley Benefield repeated, that wouldn't make it acceptable. So I vehemently disagree with Ms. O'Donnell's statement that anything the defendant says is admissible. And I'm concerned about the editorializing by Ms. Murphy being interpreted by the jury as truth, as unvarnished and documented conclusions. And so I would like the jurors to know basically the definition of hearsay. I would like the court to instruct them that it's not being offered for the truth of the matter asserted. It's an exception, and it can be considered to show how this witness reacted to it. That way, Judge White, it expands the parameters wide enough that the instruction would include hearsay from any source that Ms. Murphy refers to, whether it be Ms. Benefield, whether it be Doug Benefield, whether it be the hospital records, or Judge Moore.
All right, thank you both very much. At this point, I don't plan on giving any sort of cautionary or limiting instruction. I haven't heard the parties agree on language. It doesn't sound like the language I've suggested is acceptable to both sides. So at that point, we'll just continue with the question, objection, ruling. Specifically as to the request regarding editorializing and characterizing, I'm going to sustain on those grounds. There's been, I think my information in front of me is that Ms. Murphy is a fact witness. All right. The request that I give the definition of hearsay to the jury is denied. As we all know, the determination of legal matters, including whether a statement is hearsay or not, or any sort of evidence is hearsay, that's a judicial matter, not a legal. It's a legal question, not a factual question for the jury. Those are my decisions. I'll note that it is already factored into a court's ruling if a statement is offered, if an out-of-court statement is offered to prove the truth of the matter asserted in the statement, it is hearsay. The issue then becomes, is there a recognized exception to that statement or to that hearsay? And is it relevant and material to the case? That's how I'll continue to make my decisions, subject to the objections and the arguments that are made. Are we ready to bring the jury back in?
I have one scheduling question, if it's okay with Your Honor. We have, after Ms. Murphy, we have two law enforcement officers here, and then our next witnesses are Dr. Broder and Dr. Quintal. Do you feel like I'm safe in telling them they could come after lunch? That was when they were originally scheduled, but they have patients, and they're asking if they need to cancel to come early.
I have no idea how long these next I don't know how long Ms. Murphy is going to take. I don't know how long the next two witnesses are going to take.
Well,
I have no idea.
I guess the question is, Judge, if we end at 11:30 or 11:40, are you going to want to take a lunch, or do I need to have Dr. Broder here? Because he's in with patients right now, so I need to be able to tell him. We originally thought he was after lunch.
You mean with Ms. Murphy?
We have Ms. Murphy and then two other witnesses we plan to do before lunch. I just want to know if I'm safe to tell the doctors they can come after lunch so they don't cancel patients.
My habit would be if we finish with witnesses around 11:45, unless that very next witness was both sides agreed it's going to be just 5 minutes, I would probably take a lunch break at that point.
Thank you. I asked it poorly. That's my question. I just want to be safe in releasing them so that, Your Honor, so we can keep moving. Or not releasing them, putting them after lunch. 1:30? Should I tell them 1:30?
It depends on when we finish this morning. I
I'll
don't
just tell
know.
them it's after lunch for now. Thank you, Judge.
Are you ready to bring the jury back in?
Yes.
Defense? All right, let's bring Ms. Murphy in first. Ms. Murphy, have a seat as you're settling in. Did you discuss your testimony with anyone else outside of this room?
No.
Did anybody try to approach you and discuss anything about this case?
No.
Did you watch anything or any of the proceedings?
No.
All right, ma'am, while you were outside, I did sustain two objections that were raised by the defense, and that is some of your testimony has been editorial rather than factual, and has been characterizations of observations as opposed to observations.
Okay.
So just FYI, I did sustain those two objections.
Okay.
Otherwise, we're just going to keep having questions and answers. I'll rule on objections as we go.
Great, thank
All right.
you.
Go bring the jury in. and have a seat. Welcome back, everybody. Did anybody begin discussions amongst yourselves? Talk with anybody outside the jury about the case or do any research on the people, places, things, or legal topics we've heard anything about?
No.
Everybody says no. All right, you may resume your question.
And I believe as we left off, Ashley and Doug were not speaking to each other. Pretty much not speaking to each other.
Right, beginning on August 16th, 2019, they were not speaking to each other.
Okay. And as a result of that, did you ultimately file anything on Doug's behalf?
I ultimately did, yes.
Okay. And what was that?
We filed gosh, I think back, it was so many years ago now, a series of things, but one of the first things that we filed was an amended petition for divorce. And so it was actually a motion for leave to amend with the amended petition attached to it, which is the procedure.
So that ultimately means it was not seeking divorce before, but now the petition is.
Yes, that's correct. And still the parenting plan with some additional allegations, but that's what the main first pleading was.
Okay. And at some point after this was filed, did you get information that there had been complaints filed against Doug Benefield?
Yes, I did. So that amended petition was filed, I think, November 6th or 5th of 2019. And then within a month, I learned that there was a series of complaints filed with.
Hearsay.
Also saying.
Ultimately, these complaints that were filed against Mr. Benefield, were they documented or filed in any way in your casework, in your cases?
Object relevance.
I'll overrule.
So, of course, we didn't attach them as exhibits to our next pleading, but we did file an amendment.
Object editorialized.
Sustained. That would ask for a yes or a no.
Okay.
Can you repeat the question for me?
Those complaints, did they make their way, the information at least, into your filings in your cases?
Yes.
Okay. At some point, did Ashley file an injunction request based on these allegations?
Yes.
Okay. And around this time, was there a psychological evaluation ordered with Dr. Broder?
It was not ordered by the court. There was a psychological evaluation that was put into place through, I believe, the Child Protective
Objection
Team.
editorialized. Sometimes.
So an evaluation was recommended.
I sustained it.
I requested instruction from the board that chose to disregard the last answer.
And members of the jury, I sustained an objection. When we had our initial instructions, the preliminary instructions on Monday morning, I want to remind you of one of those very important instructions. If an objection is made, you are not to guess or speculate as to why it was made. Likewise, you are not to guess or assume or speculate what the answer might have been had the objection not been sustained and the witness had been allowed to answer. So you're to disregard those last answer.
As part of this process,
Sufficient?
I'm sorry.
Thank you. Yes, sir.
Go ahead.
As part of the process of these cases in court, did Ashley and Doug Benefield, to your knowledge, see a Dr. Broder
Yes, they did.
for a psychological evaluation?
Yes.
Okay. Do you know when this petition for injunction filed by Ashley was set for a hearing?
I don't remember the date that it was initially set because she filed a motion to continue.
Objection.
Cases?
Editorializing, not responsive to the question.
Ooh.
Go ahead.
It was continued several times after she filed a motion for mediation, and then eventually it was scheduled to occur, I believe it was September 30th of 2020.
Okay. So you said it was continued several times because of a mediation. So just what is a mediation and how does it plan?
Okay, so mediation is a settlement conference that takes place. It generally involves the parties as well as their attorneys, and then a neutral person who's generally a certified family court mediator. And so what it generally happens is a mediator goes back and forth between each side to try to work out an agreement. And in this case, it was ordered by Judge Moreland in response to Ms. Benefield's motion.
To do the mediation?
Correct.
Okay. And did you participate in the mediation?
I did.
And also Doug and Ashley Benefield?
Yes.
And as a result of that, did some of the focus of the hearing coming up change?
In anticipation of the mediation, yes, the focus of the upcoming hearing on the 30th changed.
Okay. And in what way did that change?
Earlier in September, I think on the 17th, Doug and Ashley signed a joint motion to release the psychological evaluation reports in the divorce case, in the 2018 DR 2318 case. Because in that situation, the psychological evaluations had not been ordered by Judge Moreland. They were put into place through.
Objection. Not responsive. Editorializing.
I'll sustain on the narrative.
So they did a joint motion to release the psychological evaluation?
Yes.
And is that fairly typical? It's needed in this realm to get that result released to the parties?
Oh, of course.
Objection relevance is what's taking place in this case.
Ooh.
A judge would not just release, is not able to. Oh, I'm sorry, Judge. I apologize.
A judge doesn't release that report unless?
The judge orders that it can be released.
Okay. And Doug and Ashley did a joint motion for that to happen?
They did.
And to your knowledge, what was their path forward from that point?
The path that went into place was they were reconciling and moving to Maryland.
Speculation as to what the path forward was.
And so when we were leading up to the week that he was killed, it was agreed upon that they were going to result in an impasse of the mediation because they were reconciling, and then the hearing on the 30th, the week after, was only going to be to release a psychological evaluation report,
Okay.
and they were going to pursue the move to Maryland.
Okay. So ultimately, the only thing that was supposed to happen at this hearing on September 30th was the release of the psychological evaluation.
That was it.
That was it. Okay. And do you recall what day of the week that was, September 30th?
I believe it was Wednesday. So the mediation was a Thursday prior to the killing, and then the hearing was supposed to be Wednesday the 30th.
Okay. And what day was Doug killed?
Sunday night.
And that would be the 27th?
Yes.
And who was the judge going to be at this hearing on the 30th?
It was still Diane Moreland. She was still the judge on the case.
And at all times that you dealt with Doug, did he ever seem to you overly angry or aggressive about things?
No, I thought Doug was never angry. He was very mellow and matter of fact. It was a point of contention between us, actually.
Okay. I have no further questions. Thank you.
Thank you.
Cross.
Yes. Good morning, Ms. Murphy.
Good morning, Mr. Taylor.
We've met on a few occasions, have we not?
Yes, we have.
And we meet again this morning.
It's lovely to see you.
So your specialty is family court,
Family law, yes.
and you've been practicing family law, I think you've told us, 23 years. You have your own firm, you and your husband.
Yes.
And in that capacity in family law, correct me if I'm wrong, but when you litigate matters in family court, there are rules and procedure that apply to family court, are there not?
In all courts, including family court, yes.
Okay, such as the rules of evidence,
Yes.
the rules of procedure, family court procedure,
Yes.
and ethical obligations as well.
That's correct.
Those always govern your behavior with respect to the tribunal, the court, correct?
All of our behavior, yes, that's correct.
Are you familiar with Florida Bar Rules of Professional Conduct?
Relevance, Judge?
I'll overrule. I don't know where this is going, so I'll overrule for a moment.
Thank you.
I'm familiar.
Yeah, Rule 4-3.3, candor toward the tribunal.
I'm familiar with that rule.
All right. You're familiar with that rule's obligation of a duty to disclose false evidence.
I don't have the rule in front of me, so if you want me to read and see if that's exactly in the rule, I can certainly take a look at it. I'm generally familiar with the obligation to provide candor to the court.
Yes, and to disclose if evidence is inaccurate. I think
Yes,
we can
exactly.
agree on that,
Of
correct?
course.
That would include, would it not, a failure to correct a materially false statement of fact?
Yes, I'm aware that that exists, but I don't see how that could apply to my case with Doug.
All right, well, let's see. I want to ask you about a sequence of events now relating to the litigation that you mentioned to us between Doug Benefield and Ashley Benefield.
Was this the injunction you're referring to or the divorce case?
I'll be very specific in my questions, if you'll be patient for a moment.
Of course.
Ashley Benefield files her domestic violence petition on April 23rd of 2018. Is that correct?
I believe that date is correct, yes.
Just so there's no mistake. She then, correct me if I'm wrong, because you seem to have the dates mastered, Ms. Benefield then files a petition for divorce and temporary TPR on May 31st of 2018.
I don't remember the date that she filed those, but she filed, those would be, I think, separate things. And so in response to the petition for parenting plan unconnected with divorce that I filed on Doug's behalf, she filed an answer and a counter petition seeking divorce.
So your answer for purposes of my question was you don't recall the date.
Yes, that's correct.
Okay.
And it wasn't that
May I
she was,
approach the witness?
Yes.
See if this
Yeah, I really
refreshes
don't
your recollection as to the date.
I need to get my reading glasses, Mr. Tate.
While you're looking at it, when I refer to the initials TPR, what does that stand for?
Termination of parental rights.
Okay.
Yes, thank you for the reminder. You're right. This is the 31st of May. And she did file a separate case. I had forgotten that.
Well, the question pending was, does that refresh your recollection as to the date?
As to the date, yes, the contents no.
Was I correct in my statement to you that the date was May 31st, 2018?
Yes.
Now, would you take a look, if you need to refresh your recollection, as to count 2, specifically paragraph 5. Ms. Benefield makes some allegations there, does she not?
She does.
All right. On June 19th of 18, you file Mr. Benefield's answer.
I don't remember that.
May I approach?
Yes.
Let's see if this refreshes your recollection.
Thank you.
Is the date June 19th, 2018?
Yes, that's correct.
All right. And that's your answer, is it not?
This is Doug's answer that I drafted and filed on his behalf.
That you
Yes.
drafted and filed on his
Yes,
behalf?
correct.
And in response to paragraph 5 of Ms. Benefield's petition, you deny it, do you not?
Objection relevant, sir?
I think.
I'll overrule on those
Yeah,
grounds.
thank you, Judge. Ms. Murphy, my question was, if you would look at paragraph 5, do you enter a denial?
I'm sorry, it's number 5 is 7 pages long, so I was just checking to see if that was correct.
Well,
Yes,
you ran-
we denied these allegations
Okay.
that he committed those acts during pregnancy.
Now, as part of that action, your client, Doug Benefield, submits to a deposition 27 days later on July 17th, 2018, does he not?
I don't remember that exact date, but he did submit to a deposition around that time frame.
Okay, and in that deposition,
Objection,
while,
pretrial motion.
Suspend.
Your Honor, she opened the door. She's already talked about,
Maybe
Would you like to approach?
yes.
Jury, here's what we're going to do. I'm going to go ahead and let you go to an early lunch. It's about 11:20 right now. So the good news is you get to beat the crowds wherever you decide to go. If you could be back downstairs in that jury assembly room where you start each morning at 12:30. And we'll look forward to getting you back up here as soon as we can after that. Please remember, if you do go out somewhere and have lunch, if you go in a group, that's just fine. You can absolutely go in your groups. But do not discuss the case at all amongst yourselves or anything about the case. Don't talk about the case with anybody outside of the jury. And please don't do any legal research or research on the people, places, things, or legal topics we've heard anything about. Again, if you're sitting somewhere, you hear, just kind of hear in the din of the people behind you something about the case, just let them know, hey, I'm a juror in this case. I need you to stop. If they don't, if they persist, please leave and report it immediately to the deputies. All right, we'll see you back hopefully around 12:45. All right, have a seat. Jury's out. Ms. Murphy, we're going to take an early lunch break. I want to remind you that the rule of sequestration has been invoked, so you're not to discuss your testimony or the questions asked of you with anyone, including the attorneys. You're not to discuss your testimony with any other witnesses or talk about what their testimony was or will be. You're not to view anything about this case.
Yes, sir.
All right, we'll see you back here. You can also be here be back about 12:30.
Okay, no problem.
All right, we'll see you guys back here at 12:30.